Hey there, guys and girls. This is James Hunter and Joanne Fultz, the co creators of the FIGU commercial courses and also the owners of the Florida International Group of MVP Realty. Today, we're excited to have one of our preferred attorneys on here today, Andrew Boy, and we're going to be talking a little bit today about reducing the liability in commercial transactions and the difference between a commercial transaction and residential transactions and kind of the ins and outs of those and the liability that comes along with those.
So don't forget to subscribe to the channel, guys. Hit the subscribe button below and also hit the notification bell so that you're notified when when we post more videos. So I'm going to turn it over to Andrew. Andrew, tell us about you and your fabulous attorney company that we use regularly.
Good morning. Hi, James and Joanne. It's a pleasure, absolute pleasure to be with you guys here today. My name is Andrew Boy. I'm a partner with Berlin Patton Ebling. We are a law firm specializing in real estate transactions, both commercial and residential. We have offices in Bonita Springs, all the way up to Tampa, and pretty much everywhere in between. We have 5 other offices in between. What I like to tell agents and our clients is we offer comprehensive representation from contract to closing and beyond. Whether it be helping you negotiate a letter of intent before you even commit to the contract itself, or if you already have that together, preparing the contract and everything in between, from preparing all the closing documents, doing the title work, handling escrow, handling the disbursement, the lease, if there is one, and everything that goes along with that after closing. For agents, I'm your partner who's always available to you. I used to be an agent myself, so I do know that when you need an answer, you need it now, not tomorrow. That's why I pride myself on being available to you at all times when you need those answers.
And Andrew is definitely extremely capable and very reactive. I can attest to that with all of the transactions that we've done with him. So Andrew, let's delve in. Tell us the main difference, in your opinion, between residential transactions and commercial transactions for investors who are looking to do their first commercial transaction. What should they keep in mind in terms of differences with their own liability, for example?
Yeah, so, well, where do I start in terms of the differences? There can be extreme examples of differences. The nature of a commercial transaction is that there's a wide array of different types of transactions. It could be purchasing land to develop something in the future. It could be purchasing a unit in a commercial building. Could be purchasing a whole new building. There's a wide array of different transactions, and with it comes different considerations. And that is why there is not really a cookie cutter contract that's used standard contracts, but in general, every contract is unique and tailored to that transaction. My law firm uses a particular template that we like to use to protect our clients. A different law firm will use a different contract entirely. If you're dealing with a developer or a builder, they might have their own contract that they like to use. So as we get into this, the question of liability and what to look out for really depends on what type of contract or what type of transaction we're talking about and the details contained in that particular contract. But if you'd like me to get into realtor liability, we can talk about that as well.
So I'll pitch in Yes, Andrew. And what I see a lot about is, and especially agents that are trying to go in from residential to commercial. And I always say this, the commercial transaction is more of a business transaction, and buying a house is an emotional transaction. And the difference is, businesses will straight up sue right away when it comes to transactions if they feel like something's not right. If you're not using the appropriate attorneys or whatnot, they're straight up to sue right away from a liability standpoint if something were to go sideways. And then on a home, typically most of the homeowners don't really have the money to sue or whatnot, so it's an emotional transaction. So that's what we see out there, and that's why I try to coach the agents to just be careful and make sure that they're surrounded by people like yourself, to stay
Yeah.
away from that.
Yeah, absolutely. Buyers and sellers in commercial transactions are generally thought to be more sophisticated, and unfortunately, like you said, that with that comes more litigious. They're not likely to have a real emotional stake in the transaction. It's more, okay, you defaulted, I'm going to sue you, and I'm going to move on to the next building that we were thinking about. So as we get into this, the overarching theme will be, you have to be careful what you say, you have to be careful what you represent, and you have to stay in your lane. If you don't know something, don't try to make a representation one way or the other, and rely on experts and your trusted partners.
Great advice there, Andrew. And in that vein, let's talk about seller disclosures, because there's a big difference, isn't there, between residential and commercial transactions in terms of what the seller is obligated to disclose regarding the building.
Yes, there's a very big difference. So agents making the transition from residential to commercial might be surprised to learn that sellers don't have an affirmative duty to disclose hidden defects of the property, or defects that would affect the materially affect the value of the property. So since the 80s in Florida, the rule of buyer beware is a thing of the past when it comes to residential transactions, because buyers aren't generally thought of to be sophisticated, though many of them are. Lots of them are first-time home buyers, don't know what they're looking for. So sellers have that duty to disclose defects that would affect the value of the property for residences. But that rule doesn't apply to commercial properties because, again, at least the Supreme Court decision thought that commercial buyers and sellers are more sophisticated. They know what they're looking for. They know what due diligence they have to do. So in a way, the buyer beware status for commercial properties still exists. However, agents really need to keep in mind what that means for them. The agents still have duties, ethical duties and professional duties, as is codified in state regulations, and your ethical guidelines for your particular board and the state. And those duties include duties to disclose, or duties to act honestly, rather, fairly, and use skill and diligence. So with that comes the duty to not lie, to not conceal, to not mislead. So if there is one of these defects, let's just say, there's a hole on the roof that's not readily observable. Agents and sellers, but I'll stick to agents because that's who we're speaking to here, really.
We're speaking to agents, but also to investors, first-time investors too. Yeah.
Right. Yeah. So this applies to both agents, investors, owners, sellers. You can't take overt acts to conceal these defects. So an example of a hole in the wall that's not really apparent, you can't take steps to conceal it or make it so the buyer can't discover it.
Right.
The thought being, if the buyer does their own due diligence, they should discover these things. But if you step in the way of it and try to conceal it, they don't have the opportunity to do that. So if you're straight up asked, is there a hole in the wall over there? You also can't mislead or lie or conceal about that, because that would go against your obligations.
Andrew, let me put you on the spot on a deal then. So we're representing a seller on a commercial transaction, and there was a claim filed on the building for insurance purposes, right?
Yeah.
And the buyer who we're under contract with, and the agent are aware of this. Is it a contractual obligation to provide the buyer with the information, or the public adjuster's inspection of that report and what's being filed from a construction claim, or not a construction claim, but an insurance claim on that property?
So did I hear you say that the buyer knows about it?
Correct. Or the seller, that the buyer does.
The seller and the buyer know about it. The buyer
Correct.
knows that a claim has been made.
Yeah.
No, there's no real obligation to turn over the reports. In that case, I would say that there would be a duty to disclose that, because it's not something that the buyer can really discover on their own. By doing their own due diligence, I don't know how they would turn that up. But do they have to disclose all the reports from the adjuster? I don't see any duty to do that. No, I'm the type that likes to get out in front of problems, so we don't have an issue down the road. So, in the issue of being transparent and heading off conflicts, a month down the road, if they ask for it, that it might be a good idea to turn that over.
Well, that's the key here, is that the other agent and the buyer have asked for the report.
Okay.
So
yeah, I mean,
not obligated to provide that.
He's not. No, they're not obligated to provide that.
Okay.
Might they want to think about that, turn it over? Yeah, but there's no obligation.
More of it's just probably scaring the buyer, I would say, that you're trying to hide something.
Yeah. Do they? If the buyer is getting financing, something I've learned is that conventional lenders, if there's an open claim, that's going to kind of stop the whole transaction in its tracks, because they're not going to be able to get a new insurance policy once they become owners, once the buyers become the owners, if there's an open claim. So if there's financing, it's kind of in everyone's best interest to disclose where they're at with that, and deal with it, because if you get to closing and that there's no resolution to that claim, it's not going to close.
Right. Yeah.
Great advice. Thank you, Andrew. So tell us another big difference between residential and commercial transactions for new investors or agents tackling their first commercial transaction is that there is an LOI involved, a letter of intent. Tell us what that is and what's the purpose of it.
Yeah, a letter of intent is not always used in commercial transactions, but pretty frequently. The purpose and the utility of a letter of intent is to come to an agreement on the basic terms of what the transaction is going to be. You can look at it as the foundation of the deal. And make it contingent upon the parties agreeing to a final contract. So in a typical LOI, you'll agree on the price. You'll agree on what the deposit might be. You'll agree on a financing contingency, certain other deadlines. If there's going to be a lease, the general terms of the lease or the lease back. If there's assets involved, you'll agree to what assets are going to convey and what price you put on them. But it's the important part is that it's not binding, generally not binding, even though many times a deposit will be put down as part of the LOI as a sign of good faith and that the buyer is serious about it. Usually that deposit, once there is an actual contract signed, will be included in the contract as either the full deposit or to be included in the deposit for the contract. But the purpose of it is to enter into a non-binding agreement and work towards that final agreement, because many times with commercial transactions, that final agreement will take weeks, sometimes even months to hash out. Once you get attorneys involved, I don't have a hard time saying that the more attorneys you get involved, sometimes it could take longer, but it's for good reason, because we're trying to protect our clients in very sometimes complex transactions. And as we're discussing over and over again, sometimes the commercial contracts can be really complex and lengthy. So an LOI is a great tool and a common tool to enter into a non-binding agreement and work towards that
Right.
final contract.
We certainly use that a lot, and I think a lot of people are surprised that that is a tool which is a big time saver. Before we start getting attorneys involved, even does everybody agree on the basic outline of the terms of the transaction? So it's a great tool to use. And just as a final question for you, Andrew, what would you say is the top number one mistake that you see new commercial investors or new commercial agents making in a transaction? If you were to choose the top mistake to avoid, what would that be?
So I think the number one would probably be making misstatements or statements that they're not certain about. As we keep mentioning, these transactions can be complex, and investors, buyers, sellers are going to turn to their agents to answer some difficult questions. If you don't know the answer, if you're not confident in the answer, let's say simple question: what is this property zoned for? If you don't know the answer, you should not provide an answer. Your answer should be, I know who to talk to. In that case, you can simply pick up the phone, call the zoning department. Many of them are very helpful with these types of questions. If it's a really complicated zoning question, your buyer wants to be certain that the use of what they intend to use the property for can be used that way. You can get a statement from the zoning department, a zoning determination letter saying, this is what it's zoned for, and yes, your plans fit what this is zoned for. You just don't want to say conclusively to either side that's asking you a question. In this example, yes, it's zoned for this, and you can use it for that. And then your customer takes that as if it's true. They close, and months down the line, they start to build something, and they're told, "Hey, you can't do any of that."
Right.
What are they coming back to?
Right.
We live in a litigious society, as I just mentioned. You guys are unfortunately on the front lines of that. So the best way to protect yourself is to, when you don't know the answer, steer them to a professional that does. That's the number one mistake.
Right. And sometimes, you mentioned the zoning, and that's a great point. Sometimes the current use of the commercial building can be grandfathered in, right? So that isn't necessarily the allowed use after that property changes hands and has a new buyer. So that's an important point to check. Don't would you say, take it for granted that, if that property is functioning right now as a car wash or a flower shop or fill in the blank, You should not take that as a given that that property will function and be able to function legally in the same way after it's sold, correct?
Yeah, that's correct, and it raises a good point, because you might be grandfathered in, but if you make renovations to a certain degree, or if you knock down the property and build it back up, well, those grandfathered in uses, for lack of a better word, no longer apply. Build it back up to something else. If it's grandfathered in car wash, like you said, and then you knock it down and you want to build a new and improved car wash, well, you might not be able to now. So that's why it's a really good, if you're investing a lot of money specifically to build something, it's a good use of your time to, pay $150 to the zoning department to get something in writing saying all of these plans that I have are acceptable.
Yeah.
Then down the line, if they say that it's not, you can say, well, you guys signed this letter. I relied upon that. I'm going to take legal action against you, zoning department, for misleading me. But I did want to touch on one other mistake, if I have time.
Yeah, we have to make this quick. I'm sorry, because we have another Zoom call after. But go ahead, Andrew.
So mistakes from the listing side would be to not have all your ducks in a row. Your seller is going to be asked to produce a lot of documents sometimes, like financials, proof that they can actually sign, tenant rolls, rent rolls, lots of things of that nature. If you didn't know that, it could be pretty jarring, and it can really destroy the transaction if you don't have all those ducks in a row. So that's a mistake on the listing agent side, just not knowing all the things that you need to have prepared.
Well, Andrew, I'm sorry to rush you. We are actually jumping on another Zoom call here in a second in the context of our online course, which Andrew features in. He's in our due diligence section, and he has a great section on, basically all the legal things to take into consideration and to be aware of when you're doing your first commercial transaction. So we had to cut him short today, I'm afraid, because we're making good use of his time. But if you would like to hear more from Andrew, feel free to connect with him directly at Berlin Patton Associates. So they have offices in Venice and in Bonita Springs in Southwest Florida. Also, don't hesitate to sign up for our course so that you can hear Andrew's take on the due diligence directly from his interview in our course at thefigu.com. And again, subscribe to our YouTube channel, guys, hit the bell, and we'll be back soon with some more great information on investing in commercial real estate 101. And don't forget, our courses are all available in French as well for our Canadian investors. Nous parlons français, n'hésitez pas à acheter nos cours à l'adresse en dessous. Andrew, thank you so much. I'm sorry we had to cut you short. We're going to jump on our next Zoom with you, and we appreciate you. And thanks very much for all the great information you provided today. Right, James?
Appreciate it, Andrew. Have a great day, Betty.
Very welcome. My pleasure.
Thanks.